Hello, and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time, 1 p.m. Eastern time, and over in Europe, it must be almost 9 p.m. I'm guessing somewhere around in there, and on into Asia and I guess in Japan, it's probably the next day already because they're on the other side of the international date line. So thanks for being with me today. We are here every Monday to talk about matters relating to trusts and estates and probate, all of those issues involved in estate planning and the working out of estates, and both for those who need to do their estate planning and for people who want to extend their professional services to people who need estate planning and estate settling services. So that's our topic for today. So, or our topic for this show, I should say. Our topic for today is powers of attorney. So, I remember when I first got out of college, I went to work for an attorney, right? A lawyer. And I started learning things about the law. Eventually, I became his law clerk, or the law clerk for the firm, because I worked for both him and his associate. And I learned about this. I learned about the distinction between an attorney at law and an attorney in fact, right? So just a little bit of background, I think, is useful, because I couldn't. It was like, wait, an attorney is an attorney, right? Or an attorney is a lawyer. So that's not true. An attorney is someone who acts for another. So an attorney at law is someone who's acting for another with respect to the law, a lawyer, in other words. But an attorney in fact is a type of agent where that person acts in place of, in the stead of, the principal. Okay, so when you have a power of attorney, you've got a principal, that's the person who's giving the power, and you have the attorney in fact, or the agent, that's the person who's getting the power and is now going to act on behalf of the principal. Now, this is important because in the estate planning process, there may very well be a need for various powers of attorney to be drawn up and used depending on how your estate plan is set up. And as a professional, you may need to be an attorney in fact if you're not a lawyer, but that attorney in fact comes with duties, obligations, etc. So let's do as we do. Do as we do. That's a silly thing. Anyway, we're going to go ahead and share my screen here. This is our PowerPoint for today, Trust and Estate Weekly. There you go. And I always like to make a brief mention of the 3 pillars of attainment, because all of the Way to Wow shows are based on this concept. We deal primarily over here in the pursuits pillar and in the finances realm. However, when we're dealing with powers of attorney, we're inevitably going to be dealing with relationships. Okay, who is going to be our attorney in fact? Is it going to be a family member, or is it going to be a friend or a colleague? That's something that we're going to have to determine. There we go. Okay, so let's talk about what a power of attorney is. So I mentioned this just a minute ago. Under a power of attorney, a principal appoints an attorney in fact or an agent. This is someone to act on their behalf. Okay, now, why would someone need an attorney in fact to act for them? Well, it may be that they cannot be present to do something. Okay, so now here in California, when we close an escrow transaction, We have, when we close a real estate transaction, I should say, we have escrow. So the parties do not need to be physically present to close the transaction. But there are still some states where you have face-to-face closings where the buyer and the seller meet essentially across a table, and they pass documents and funds back and forth across the table, and there's a formal closing. So if one of the parties to the transaction cannot be there, typically their lawyers will represent them, but there may be a need for them to be there and they can't be, so then they would appoint an attorney in fact to be there in their place. Okay. Now, another situation where a power of attorney might be necessary is if the person has become mentally incompetent. Okay. Now, let's be clear here. Someone who's mentally incompetent cannot appoint an attorney in fact. Okay. So the attorney in fact was established, was appointed prior to the person becoming mentally incompetent. And because of how that power of attorney was set up, it survives the principal becoming mentally incompetent. Okay. So we're going to talk a little bit more about that when we talk about types of powers of attorney. Okay. But just keep in mind that a person has to be competent at the time they establish at the time they appoint an attorney in fact. Okay. Now, the person acting as the attorney in fact is a fiduciary. Now, I've talked in other shows about what a fiduciary is, but let's go over it here because it's important to understand this for both the principal and the agent. A fiduciary must act for the best interests of the principal, always, period, full stop, as we say. The fiduciary can never put his interests above that of the principal. Okay, this is a higher level of obligation than, for example, a retailer might have. All right, if you go into Banana Republic, right? And you're looking at, I don't know, a pair of pants, and and the salesperson is like, "Oh yeah, that looks terrific," right? They have no obligation to consider your best interests above theirs. Okay, their obligation is to the store; it's to get you to buy the garment, and that's it. All right. Now, if they were your attorney in fact, right, and I don't know, they looked horrible. Presumably, they couldn't say, "Oh yeah, they look great," right? Because that's not to your benefit to look, horrible. Okay, I'm being somewhat tongue in cheek, but understand that this fiduciary obligation is very, very high. Okay, and it is a legal obligation. It's a moral obligation too. I think we could effectively argue, but breach of fiduciary obligation is a serious breach. Okay, and it will expose the agent in fact, the attorney in fact, to a great deal of liability. In fact, they could be liable not only for whatever loss they caused their client, but they could be sanctioned as well, depending on why the breach happened, how it happened, was it intentional, was it not, etc. Okay, so the attorney in fact, the agent, is a fiduciary. Now, powers of attorney can be either limited or general. Okay, a limited power of attorney, as its name states, gives the attorney in fact authority to act only in specific circumstances that are delineated in the power of attorney. Okay, so for example, someone could establish a power of attorney that allows the attorney in fact to handle routine banking matters for them. Okay, maybe they're just not as mobile as they used to be. Excuse me. And so it's difficult for them to get to the bank. And so the attorney, in fact, has the authority to handle banking matters. Okay, that would not give them the authority to sell their house, buy a car for them, or anything like that. Okay, it's limited in scope. Okay, that's as distinguished from a general power of attorney, where the person, the attorney, in fact, can basically do whatever the principal could do. Okay, so an attorney, a general power, under a general power of attorney, an attorney, in fact, could do routine banking, could sell the house, could buy the car, could do virtually anything. Okay, now there are certain institutions that will not accept a general power of attorney. In other words, there are certain banks where if I was someone's attorney, in fact, under a general power of attorney, they would not let me walk into that bank and close the account and get a check for all the money. Okay, they would want to see in the power of attorney the specific authority to open bank accounts, close bank accounts, whatever it was that I was trying to do. Okay, so in some cases you'll see general powers of attorney where they also specify specific tasks. Sounds so trivial, but certain activities that the attorney, in fact, can do in order to make sure that the various financial institutions, et cetera, will accept the power of attorney. Okay, and they may say something like, including but not limited to the following, the following powers. Okay, now. And we're going to talk a little bit more about limited versus general powers of attorney too, when we talk about types of powers of attorney. Okay, last on this slide is the authority of the attorney, in fact, to act always ends when the principal dies. Okay, a power of attorney cannot survive death of the principal. Okay, it may survive the principal becoming mentally incompetent, to go back to a point we covered a little while ago. But when the principal dies, that's it. The power is done. Okay, and now we go into essentially an estate situation, and whoever is empowered to handle the estate for the deceased principal, now that person has the power and authority to act on behalf of the estate. Okay, now, by the way, it could be the same person. The person could be an attorney, in fact, while the person is alive, and could be a trustee I should say a successor trustee under the principal's trust. Okay, or it could be a trustee under the principal's trust as well. Okay, the two could be combined in one person. Okay, but it's because the person has both buckets of authority, if you will, that the person can continue acting. But once the principal dies, they're acting under a different set of authorities, not the power of attorney. Okay, all right, let's go on to the next one. Is this going to click? Yeah, okay, here we go. All right, so let's look at types of powers of attorney. Probably I don't know if it's the most common. I'm not going to say that, because these days it's hard to say. But the first one we're going to talk about is a non-durable power of attorney. Okay, a non-durable power of attorney. The power of the attorney, in fact, to act ends if the principal becomes incapacitated, meaning mentally incompetent, typically. Okay, so in this case, you don't even have to wait for the principal to die for the power of attorney for the power of attorney to essentially cease to be effective. once the principal is mentally incompetent or otherwise incapacitated, that's it. Power of attorney, done. Okay. The attorney, in fact, can no longer act for that principal. Okay. Now, contrast that with the durable power of attorney. Okay. In a durable power of attorney, the attorney, in fact, continues to have authority to act for the principal even after the principal becomes incapacitated. Okay. So just to go back for a moment and clarify, right? When we were talking about powers, we said the attorney, in fact, can act when the person is mentally incompetent. That is the case if the power of attorney is a durable power of attorney, meaning it continues to be in force after the principal becomes mentally incompetent. Okay, so that's one big distinction. Okay, now then you have something called a springing power of attorney. This is a power of attorney that lays sort of dormant, if you will. The attorney, in fact, has no power to act until a specific condition is met. Okay, so for example, you see these in estate planning where healthcare decisions need to be made for someone who is incapacitated but alive. Okay, and who's going to make decisions, medical decisions for that person? So a springing power of attorney will give the authority to an attorney, in fact, to make decisions about that person once that person is incapacitated. Are they, if they code, are they going to use extraordinary means to resuscitate the person? What kind of healthcare are they going to get, et cetera, et cetera, et cetera. There's, obviously healthcare can be, oftentimes is very, very complicated these days. Who's going to make those decisions? And by the way, there could be religious aspects to these decisions. Okay, so someone's faith, someone's religion may require them to be resuscitated, so that there's not what might be looked at from a religious standpoint as a sort of frivolous taking of life. Okay, but at what point would the efforts of the doctors and nurses to resuscitate this person become disrespectful enough to the point where it would be permitted to, let the person die? Okay, so a springing power of attorney may point as an attorney, in fact, a religious I don't want to say person, like a priest or a rabbi who is qualified to make that call. Okay, so that's a springing power of attorney. When a specific condition is met, then the power of attorney becomes active, and the attorney, in fact's authority to act begins. Okay. A financial power of attorney. Now, this is typically limited. This is a type of limited power of attorney that allows someone to make financial decisions and engage in financial transactions on behalf of the principal. Okay, so I mentioned, a little while ago, someone having a power of attorney to handle routine banking matters. That could be a financial power of attorney. Okay, typically they will be broader, so they will allow financial transactions, but for example, they wouldn't allow the attorney, in fact, to make medical decisions in the sense of whether the person gets resuscitated if they code and all that kind of stuff. Okay, so this is a limited power of attorney, although it is still quite broad depending on the extent of the principal's finances. Okay, and then finally, there's a medical power of attorney. And as it says here on the slide, it gives the principal the authority to make healthcare decisions. Okay, and and this is distinguish this from a springing power of attorney that's done for medical reasons, in that a medical power of attorney may give the attorney in fact authority to make decisions from the moment that the power of attorney is created. Okay, so a springing power of attorney, by the way, doesn't have to be only medical matters. It could be others as well. But if you could have a springing medical power of attorney, which means the attorney, in fact, can only make decisions about the medical situation of a principal once a certain condition is met, or you could have a medical power of attorney that gives the attorney, in fact, that authority right from the get-go. Okay, so these are not mutually exclusive categories. Okay, and by the way, the springing power of attorney it's probably going to be a durable power of attorney as well. Okay, so something may happen to trigger the springing power of attorney, and the person may not necessarily be incapacitated per se. It just may be the person's wish that if they have to go in the hospital, they don't want to be burdened with making healthcare decisions. And so, they go into the hospital, that triggers the springing power of attorney. But that springing power of attorney is a durable power of attorney. And if the principal should become incapacitated, the attorney, in fact, will still have the authority to continue making decisions. So you can see how these can be sort of mixed and matched, so to speak, into many different variations. Okay, and it's not, although the ones I've seen typically are labeled as durable, non-durable, springing, whatever, the label isn't necessarily germane. Okay, what's important is, what does the body of the power of attorney give the attorney, in fact, the authority to do, the power to do, and when? Okay, those are basically the two main issues relevant in a power of attorney. Let's see, we're doing okay on time. Great. Okay. So now I want to take just a minute to talk about a military power of attorney. Okay, for those of you who are in the military, whether you're active duty or whether you're a reservist, oftentimes, if the service member is going to be deployed outside of the 50 United States, they will essentially be told by their unit, hey, make sure your spouse has got a power of attorney. Okay, and the reason is because if the service member is deployed, wherever, the Philippines, Iraq, Syria, wherever they are, Horn of Africa. Okay, it can be difficult for the spouse who's at home to get things done without their service member spouse being there. And so in order to handle day-to-day affairs, okay, the deploying service member will give his or her spouse a military power of attorney that will allow the spouse to do whatever needs to be done in their absence. Okay, so it's sort of almost a general power of attorney, but it's for a limited period of time, basically, because it's typically used only while the service member is deployed. Once they get back, the power of the attorney, in fact, the spouse typically to act, will terminate, and things will go back to normal, where they both have to be involved in handling whatever day-to-day affairs there are to handle. Okay, so it's typically going to be a general power of attorney, and it's not a springing power. Well, it's kind of like a springing power of attorney, because it's usually not given until the service member deploys, although technically it's not really a springing power of attorney, because they'll set it up and it'll be valid as of a certain date when the service member is unable to handle day-to-day affairs. Okay, so that's a military power of attorney. And I think that's what we've got for today. Yep, we're good. Okay, so where do you get help? Here you go. Here's just some links here. I show this just so I remember to mention that my contact information will be in the show notes. If you have any questions, feel free to send me an email, drop me a comment in the various social media. I mentioned these three, but you can also reach me through Telegram. There's a Wait a While Telegram group. You can reach me through Pinterest. I'm on Instagram as well. So you can always message me through those. If you have any questions, comments, criticisms, feel free. Always happy to hear what you have to say. And particularly if you think I've said something wrong, by all means, let me know. And if I have to issue a correction, I will, and we'll do so in your name if you wish that to be the case. A couple of notes before I sign off. One is, if you are involved in estate, trust, and probate matters, and have something of interest, informative, for the audience, do let me know. I'd be happy to have you as a guest on the show. So it's fun to be able to talk with professionals. Like I had Paul Hilton on a few weeks ago. He was an estate planning attorney. We have some other guests coming up, later in the year. So always happy to have a guest on for a half hour conversation. Tomorrow is my show, Business Lessons from the Military. Okay, that's at 11 a.m. Pacific time, 2 p.m. Eastern time, and then an hour in for Central and Mountain time. And we're gonna go, after having had guests and some digressions, we're gonna go back to talking about Marine Corps warfighting doctrine and applying it to the business world. And so I hope you'll join me for that ongoing conversation. And then on Wednesday at 12:30 p.m. Western time, Pacific time, 3:30 p.m. Eastern time is my show, People Making Money. And I have a guest, and I don't want to mangle his name, but he's with Honorable Marketing. This is a digital marketing service, Army veteran. And so I encourage you to come and hear Paul's story. It's interesting. Paul Hilton, I think it's Makowitz, but I'm not 100% sure how Paul pronounces his last name. He's a new friend of mine. But I think you will gain a lot out of, first of all, seeing how Paul's career path has developed, as well as hearing about digital marketing and that whole aspect of business today. It's so important to getting our success. And then next week on Monday at 10 a.m., will be the next edition of Trust and Estate Weekly, and we will start all over again. So I do thank you for joining me. Here's all the legal stuff. And let's go ahead and stop out of the share. And so thank you very much for joining me. I hope you enjoyed the show and that you got something out of it. If you know people who are involved in estates and trusts, please pass it along to them. And let's all learn together and benefit each other. And if you think about it, if you're not a subscriber, maybe hit that subscribe button on YouTube. And that way you'll always know when a new episode posts, not just of Trust and Estates Weekly, but of all my shows. So thanks again for joining me. I hope you have a wonderful rest of the day and look forward to seeing you tomorrow and the rest of the week.